Well, welcome to the second video on Tutorial 4. This one's going to look at the European Union issues because, of course, the second half of the course, and when it comes to the exam, half the exam paper, looks at the European Union. And I made two very important points. The first is that it's important to distinguish between the European Union and the European Convention on Human Rights. If you look at the marking criteria, you'll notice that for a fail there is a phrase fundamental flaw. And giving the impression to the examiner or giving the impression to someone marking your TMA that you don't understand the distinction, that you've confused the EU with the ECHR, can often be regarded as a fundamental flaw. And so I've produced another handout, and again I'm happy to send it to anybody who wants it, looking at some of the differences. And it's important that you do this. Now, it's not helped by the fact that very often the press and politicians blur the two. They talk about the European Court as if there were only one. They talk about European law, again, as if there were just one thing that was European law. In fact, the European Union law and the law relating to the European Convention on Human Rights are completely different. So you may hear people say, oh, I'm opposed to the European Union because they won't let me smack my children. They are confusing the EU, which has nothing to say on the matter, with the Convention on Human Rights. So the key differences, and you can see how immense those differences are, is that the EU has 27 members. The ECHR, which was created by the organisation the Council of Europe, has 47. The Council of Europe was founded in 1949. Britain was an original member. It set it up. It played a key role in writing the European Convention on Human Rights. Whereas the EU and its predecessors, the European Coal and Steel Community, the EEC, the European Community, depending which period of time you're talking about, that starts in the early 1950s. Britain has no initial involvement, joins only in 1973. And the legislation that brings the two into British courts, EU law, it's the European Communities Act of 1972. The Human Rights Act of 1999 is the legislation which deals with the European Convention on Human Rights. So very important that you distinguish the two. We then moved on to the question of rights that arise under EU law. Now, two phrases very similar but need to be distinguished. Direct applicability means that law made within the European Union, brought in by the Commission, decided upon jointly between the Council of Ministers and the European Parliament, where it's made in Europe in that sense, where it goes directly into national law, that is said to be directly applicable. And that is an attribute of regulations. So regulations, once they've passed all their stages within Europe, they will apply into British law without the British government having to do anything else. Direct effect is all about rights. It's rights which arise in European law, which the national courts, or even your local courts, be it in Milton Keynes, in Birmingham, or wherever, can be called upon to give effect to. And for a right arising in European law to be seen as having direct effect, certain things need to be shown. The first is that the right is clear, precise, and unconditional. Now, in a TMA question or an exam, that is nice and straightforward. If it looks like, if it feels like a right, it is. Only if it's conditional, it's dependent upon something else, does it not meet that criteria of clear, precise and unconditional. As I say, that is normally no problem. All we're looking for from you is that you recognise that it has to have that attribute. Now, wherever in European law the right arises, clear, precise and unconditional is needed. But if it arises in a treaty article, or it arises in a regulation, then clear, precise and unconditional is sufficient. But if the right arises in a directive, two further things are needed. So the second one is that the date of implementation needs to have passed. Again, that's not going to cause you any problem at all. You look at the date, you look at the date that the question is asking about, and if it's before, it can't have direct effect. If it is after, then it can. The important one is it an emanation of the state? And this is why it's so important that you look at the case of Foster and British Gas, because that shows the sort of things that the courts take into account when looking at a body which on the face of it doesn't appear to be a public body, but which, because of what it does or the powers it has, is, for European Union law purposes, to be treated as an emanation of the state. Now, if you've looked at all those and you've come to the conclusion that yes, all three are met, then there is direct effect. If your conclusion is that they're not, or they might not be, and very often the questions are not as clear-cut as you can say for definite, then you need to move on to the question of whether those rights can be given effect under the principle of indirect effect. And this is where the National Court looks at the national legislation, looks at the EU legislation and says, can we read the national legislation to give effect to that right in European Union law? Sometimes it's possible. In other cases, it isn't. If the national law gives the right after 12 months and EU law says 6 months, then it's impossible to read the national law of 12 months to mean 6. You can't add the word not in, for example. So, again, it may be possible to give indirect effect. If that isn't possible, then you get onto the question of state liability. This means a different action. An action for direct effect or indirect effect will be against the body, the individual who has denied you that right. Whereas the state liability is an action against the state, analogous to a tort action, because the state, the UK here, has done you wrong by not giving effect to the right which European law has attempted to give to you. And again, you'll see that there are 3 criteria and they are listed on that sheet. So that's the important points about EU law. It's going to dominate your studies for the next few months, but these 2 ones are very important, and even if it takes a while for the penny finally to drop, do invest some time in this because they are crucial to your future studies. Well, thank you.